Well, a bit of a legal update today, and last December we presented a petition to Parliament. It had 87,269 signatures calling on the government to allow the use of COVID rapid antigen testing as an alternative for unvaccinated Kiwis so they could access workplaces, schools, marae, large gatherings and places of worship. And we argued at the time that with our evolving understanding of the waning immunity of the vaccine, the new variants and the need for boosters, we thought that testing was an important component for all New Zealanders moving forward, and it would be much fairer and wouldn't divide us. Now, of course, rapid antigen testing is now the gold standard. But there's also been some other legal stuff going on, and I wanted to update you on that. Let's check it out. So also last December, as part of the next stage of the Don't Divide Us campaign, our legal team filed an application to the High Court in Wellington for a judicial review on the church vaccine mandate. It was on behalf of a group of 15 applicants representing 110 churches and 2 mosques. And we were asking for a less restrictive, more proportionate policy to be applied at that time. Once again, we promoted rapid antigen testing as an alternative to vaccination for conscientious objectors, particularly in the context of religious and faith-based gatherings. It's important to note this group didn't oppose vaccines. In fact, one of the churches actually ran a vaccine drive, but they did oppose mandates. And what was being sought was actually in step with how most of the governments of the Western world were treating the right to manifest religion during COVID. So let me hand it over to our legal team, Madeline Flanagan and Graham Edgeler, to give you a quick overview of the case and the 2 days in court.
So I'm Madeline Flanagan and this is Graham Edgeler, and we have just completed 2 days of hearing in Wellington's High Court on the issue of freedom of religion amid the COVID-19 pandemic response of the New Zealand government. We act for 113 churches, mosques and ministers.
The case was a challenge to the COVID rules that the government adopted in December around the use of COVID vaccination passports and the requirement that churches use them if they want to meet. The argument was essentially that the government had another option, that it should have applied less stringent rules to churches, perhaps the same rules that it applied to schools. Schools were allowed to open with students and parents being allowed to attend without COVID vaccination certificates. And we said if it was safe enough for schools, it should have been safe enough for churches. And so the challenge was to ask the government for a good reason. Why are you treating religions, why are you treating churches and mosques worse than you're treating schools? Because the right to an education is important, but the right to your religion is important as well. And so the challenge is taking those two rights and looking at them together and saying, is the decision the government made to require COVID vaccination passports to be used in churches and mosques, is that a reasonable decision given the importance of the right to freedom of religion?
And we want to make it really clear that our clients were not saying that COVID-19 was not serious. Our clients were not saying the government shouldn't have done anything or it should have just left churches and mosques to make their own decisions. Our clients were very responsibly saying, look, the government had to step up and it had to put some serious policies in place to protect New Zealanders because COVID could come into mosques, it could come into churches, and obviously it's a very it's a very worrying disease and it's had a very worrying impact on society. But what the churches were saying was, look, we were a highly vaccinated population at the point the traffic light laws came in. We were almost at 90% double vaxxed, and the leaderships of the churches and mosques in our case were very pro-vaccination themselves. Their congregations were highly vaccinated, and they were just saying, look, we don't want to have to exclude people. We want something like an Air New Zealand policy or a Jetstar policy. You know, you can come on the plane if you show your vaccine pass or your rapid antigen test result, and the churches were saying the same thing. We want to offer a safe environment for people to come and worship, but we don't want to turn anybody away. And our clients felt that those lines could have been better drawn, and that is what they have asked the court to decide. So the decision, how far away is that, do you think, Graham?
We don't know how long the decision will be away. It's another thing perhaps important to realize, we're not asking, the churches aren't asking for money or anything like that. They're asking for the court to look at the decision and decide was the decision of the minister lawful? Did Parliament give them the power to make these sorts of rules and impose them on churches in circumstances where perhaps, and we say there were, other alternatives available to the minister when this decision was decided?
Because one of the things you've got to remember is that the right to practice your religion in public with others is a protected right under the New Zealand Bill of Rights Act, and it's also protected in international law with very similar wording in the UN.
The International Covenant on Civil and Political
Rights.
Rights.
I started to fall over that for a minute. And the thing is, the right's important. It's one of the fundamental rights that ground our society as a free and democratic society. The idea that you can form beliefs. Those beliefs might be religion, they might not be religion. You can live in accord with them, you can vote in accord with them, you can assemble with others in accord with them, you can speak in accord with them, and you can practice them. And those rights, being able to practice in that way is really important, and it's really important that the same rules are applied to things of equally similar importance at law. So you can't have something that's a protected right being treated in the same way that you would treat the right to access the library. You know, if something's a protected right, like the right to movement, then things like the right to get on a plane with either a vaccine pass or a rapid antigen test is important. There has to be a way for you to be able to exercise those important fundamental rights safely, whilst balancing the important need to protect society against COVID-19.
There we go. So thank you to Graham and Madeline. We wait for a decision. It's an important test on the right to practice religion in New Zealand. Just before I go, we're also asked on a regular basis, what's happened with Family First's charitable status and our case in the Supreme Court? Well, despite the hearing being 12 months ago, we're still awaiting a judgment from the 5 Supreme Court judges on the government's attempt to deregister Family First as a charity. It is a significant case, and you can be assured that when we receive the judgment, you'll be the first to know, because that is the reason that they want to deregister us, our views. And there's also a school in trouble at the moment for holding similar views. Now, the other thing, we've been contacted by many counsellors, pastors and parents asking us how to interpret the new law which bans conversion therapy. What's allowed and what isn't? It's a very good question, and because of a badly drafted, vague and ideologically driven law, we don't have a legal question that we could give with confidence. So we're now getting that legal advice from a public law legal expert to assist you, and once we receive that legal advice and digest it, we will be able to update you. Whew. Lots of legal stuff today. Thanks for hanging in there. See you tomorrow.